Kindly note that the session will be recorded for the official purposes. Good morning, Your Ladyship and learned councils. Welcome to the 6th TGA Virtual Moot Court Competition. My name is Shabidas and I will be acting as the court master for this session. It is my distinct honor to welcome our esteemed judge, Advocate Richa Joshua, for this round. Ma'am has about 8 years of practice as an advocate enrolled with the Bar Council of India, experience in the area of civil and commercial litigation, with focus on civil and banking laws, Consumer Protection Act, matrimonial cases, negotiable instruments, etc., before various courts and quasi-judicial authorities in the states of Telangana and Andhra Pradesh, including high courts, district courts, DRT, RERA, arbitral tribunals, etc. She also has experience in commercial corporate work, including general advisory practice, conveyancing, commercial documentation, legal audits, title investigations, and due diligence for real estate transactions. We thank you, ma'am, for your valuable time and efforts in adjudicating this session. Before we proceed, I request all the participants to ensure that they have a stable internet connection. Please keep your cameras turned on throughout the proceedings. If you experience any technical glitches or connectivity issues, kindly communicate this through the chat box. In the event of a disconnection due to poor connectivity, a maximum extension of 5 minutes will be granted to the affected counsel to reconnect. With the permission of ma'am, may I proceed to outline the rules of the competition?
Sure, we can proceed.
Thank you, ma'am. The structure of the proceedings will be as follows. Counsel 1 and Counsel 2 for the appellant will present their case, followed by Counsel 1 and Counsel 2 for the respondent. Each counsel is allocated 15 minutes. Any extension beyond this time is solely at the discretion of ma'am. However, I humbly request ma'am to avoid granting any extension due to fixed schedule. As court master, I will be strictly monitoring the time. Screen sharing of judgments or documents is permitted only with the prior permission from ma'am. We now commence the session. All the best to all the teams.
Counsel seeks permission to approach the virtual dais.
Permission granted.
May it please this honorable court, this is the counsel appearing on behalf of the appellant in the case of ABC Bank versus XYZ Private Limited. Your ladyship, would you appreciate a brief perusal of the facts?
Yes, you may go ahead.
Much obliged, your ladyship. Your ladyship, the facts in the present case are as follows. ABC Bank sanctioned a 500 crore loan to XYZ Private Limited in the year 2013, and the same was classified as an NPA on 1st April 2014. Thereafter, your ladyship, after failed restructuring and OTS attempts, two Section 7 IBC applications were filed. The first one, your ladyship, was filed in 2020 and it was dismissed under Section 10A during the COVID moratorium. And the second application was dismissed on the grounds that the appellant in the present case cannot alter the dates of default and also on res judicata. Both these applications were taken to the NCLAT and were dismissed before the NCLAT as well. The present case, your ladyship, arises before the Supreme Court on the dismissal of the second application by the NCLAT. There are four issues, your ladyship, that arise in the present context. The first one being whether or not a second application under Section 7 is barred by law. Secondly, whether or not mentioning the date of default is mandatory in applications under IBC. Thirdly, whether or not the date of default changes based on facts and circumstances, or is it to be taken as the date of the NPA in all bank matters? And finally, whether or not a case can be admitted if the default has occurred and the application is within limitation despite an error in the date of default. Your ladyship, the present counsel will be dealing with the first two issues at hand, followed by my co-counsel who will be dealing the third and the fourth issue. With the permission of your ladyship, may the counsel proceed with the arguments?
Yes.
Much obliged, your ladyship. Your ladyship, the first issue at hand is whether or not a second application under section 7 is barred by law. It is the most humble contention of the appellants, your ladyship, that a second application under section 7 is not barred by law in the present context. And to elaborate on the same, this council would like to put forth 3 arguments before this court. The first one, your ladyship, is that the applicability of res judicata will not apply in the present case. Your ladyship, the appellant would like to submit that res judicata under section 11 of the CPC will not apply to the dismissal of a second section 7 application, as it was rejected solely on procedural grounds. It may be noted, your ladyship, that the second application by the NCLT and the NCLAT was dismissed on solely the premise that the date of default has changed. Therefore, your ladyship, we regard this as merely procedural, and therefore, your ladyship, such a procedural dismissal cannot be made in cases where cannot be made or held to be a ground of res judicata. Your ladyship, we understand that in the first application, the NCLAT dismissed on merits. However, your ladyship, it is very pertinent to note or to put forth before this court that the first application erred in the date of default. The date of, and your ladyship, I will be also addressing in my later arguments that the date of default cannot be the sole basis for a dismissal of an application. Therefore, your ladyship, the fact that in the first application solely on the date section 10A was applied and dismissed, decided on merits, will not apply a res judicata bar in the present instance, your lordship, because the present instance records the true date of default, which is in 2014, and thereby the continuing cause of action via the OTS acknowledgements, which I will also deal with in my proceeding arguments. Your ladyship, the second limb I would like to put forth before this court is the extension of limitation through debt acknowledgement. Your ladyship, we understand that the period of limitation under 137 is 3 years. However, your ladyship, section 18 of the Limitation Acts makes it clear that when there is an acknowledgement of debts, the limitation period will thereby continue, and each acknowledgement of the debt will constitute a fresh period of limitation. Thereby, your ladyship, if I may also put forth before this court the extremely landmark judgment of Lakshmipat Surana versus Union of India, where similar letters of acknowledgements revived claims under limitation. Thereby, your ladyship, we would like to submit before this court that in the present instance, where there is no doubt, there is no ambiguity, the respondents in the present case or themselves have acknowledged their debts as late as 2022, the aspect of limitation alone will not bar the present petition. This, your ladyship, brings me to my final limb of argument on the first issue, where this council would like to shed light on the permissibility of a second Section 7 application for cases where there is continuous default. Your ladyship, it is submitted that a second Section 7 application remains maintainable where the corporate debtor's default is continuous, and the prior filing, therefore, your ladyship, being invalidated by a temporary legislation will not bar the present petition or will not bar a second Section 7 application. Your ladyship, the case of the NCLAT in the very landmark judgment of Deshbhushan Jain versus Abhay Kumar in 2024 held that every default is a new cause of action. Therefore, your ladyship, we understand that in the present case, the fact that XYZ Limited's loan amount was classified as an NPA in 2014 and the repeated acknowledgements via OTS have accrued as late as 2022, there is a case where a second application is available, because it also may be noted, your ladyship, that OTS was granted to the respondent in the present case, which they refused to adhere to, which was subsequently cancelled. Your Ladyship, the respondents cannot attribute the same to COVID-19 because that debt did not accrue during COVID-19. It was a debt that was payable in 2014, out of which there is a recurring action. Therefore, Your Ladyship, the respondent in the present case cannot substantiate that the failure to pay the OTS when it was sanctioned was due to COVID-19. Therefore, we understand, Your Ladyship, that there is a blatant case in the present hand where there has been consistent defaults by the respondent herein. And therefore, Your Ladyship, we believe that a second Section 7 application is the need of the hour to ensure that the rules that the IBC was made for itself, that is the maximalization of assets, and also, Your Ladyship, the basic principles of natural justice when it is a case where the existence of the debt is not questioned, the existence of a default is not questioned, merely on some procedural inconsistencies, these applications are being dismissed. Therefore, Your Ladyship, with all the grounds that I have already put forth before this court, I would like to conclude my first issue by saying that the second Section 7 application is within all ambits of law, and therefore its dismissal was erroneous, and this court may decide appropriately. If Your Ladyship has no further questions regarding the first issue, I would like to move on to my second issue, Your Ladyship, or if you have any questions, I would love to address them as well.
You can proceed with the second issue.
Much obliged, Your Ladyship. Your Ladyship, the second issue before this court is whether or not mentioning of dates of default is mandatory in applications under IBC. Your Ladyship, I would like to elaborate on this argument on two broad limbs. The first one, Your Ladyship, being that the nature of this default date specification is not mandatory, and various judgments of the NCLT, NCLAT, and the Supreme Court have elaborated or interpreted in the same manner. Your Ladyship, the purpose of mentioning of a default date is for verification of the default. Thereby, Your Ladyship, the essentials of admitting a petition or the mandatory requirements of a Section 7 application are two things. The first one, the existence of a debt, proving the same, and thereby the existence of a default. Courts, Your Ladyship, in the NCLT and the Supreme Court have always been flexible while deciding what the date of default is. In fact, courts have also gone to the lengths of asking for the respondents to have also gone to the extent of asking the appellants to rectify the date of default if they found inconsistencies. Therefore, Your Ladyship, the date of default itself will not be mandatory in an application. If I may to substantiate the same on case laws, Your Ladyship, I would like to quote the case of Geocon Infra versus Bridge Gopal Construction, wherein in 2023, Para 22, Your Ladyship, may I please request for my researcher to screen share the judgment, Your Ladyship, or may I just quote it?
You can screen share the judgment.
Much obliged, Your Ladyship. Your Ladyship, Para 22 of the Geocon Infra versus Bridge Gopal Construction Company Private Limited case says that therefore the default occurred, and thus we assume the date of default in the present matter to be so and so. Hence, we observe that the non-mentioning of date of default does not affect the merits of the present case. Paragraph 22 will discuss the same, Your Ladyship. In the present case, Your Ladyship, the application did not mention a date of default. However, the court held that non-mentioning of the same will not affect the merits of the case itself, and the court appreciated the evidence and the records put forth by the bank or the financial creditor in the case, and they deduced the date of default. Therefore, we understand, Your Ladyship, that when the financial creditor has to fill Form 1 for a Section 7 proceeding, there is no mandate that the date of default must be mentioned. This is not only one case, Your Ladyship. This has been reiterated multiple times Even in the case of TLG India Private Limited versus Puranik Builders Limited, in paragraph 2.1, I'm quoting your ladyship, it says, the date of default is not stated in part 4 of the application. However, after considering the pleading therein and the details of the invoices annexed to the application, the date of default is determined as 25/10/2019, 30 days before the last invoice. This case also, same situation, your ladyship, where the date of default was not mentioned in the case. However, the court said that we will consider the pleadings, we will appreciate the invoices put forth before the operational creditor in that case, and we will deduce a date of default. Therefore, your ladyship, we very well understand that this mentioning of date of default is not mandatory. We understand that it is very important to the CIRP proceedings or to a Section 7 application, but non-mentioning or changing the same itself cannot be a ground for dismissal, your ladyship. This brings me to my second limb of argument on my second issue, your ladyship, which is the curability of errors when it comes to default days. In the first sub-issue, your ladyship, we saw how the date is not mandatory. I would now like to shed upon how courts have allowed for amendment to the default date, whereby they have appreciated evidence and they have said, your application says a wrong date. We allow you the opportunity to rectify the same, which in both the applications was not allowed to the appellant herein. Your ladyship, the case of Puneet Bhatia versus ASREC Limited, where the NCLAT Delhi bench, your ladyship, in 2024 held in para number 25 that the adjudicating authority is empowered to allow amendment of pleadings even after pleadings are closed, but before the pronouncement of the final order. Furthermore, your ladyship, they also placed reliance in the case of Dena Bank, wherein in para 30 it was stated that the amendment was allowed on the dates relying after the adjudicating authority relies on records. Therefore, your ladyship, we understand that where courts have seen that the date of default in the application is wrong, they have gone forward and asked the appellants or the financial creditors to rectify the same. Your ladyship, I believe my time is up, your ladyship. May I just ask an extension of 1 minute and I will conclude my arguments, your ladyship.
Just a minute.
Yes, your ladyship. Therefore, your ladyship, we understand that courts have been very clear when firstly, if the date is not mentioned, they appreciate evidence and they deduce the date. Secondly, your ladyship, where the date is wrongly mentioned, they ask for the operational creditor or the financial creditor to rectify the same. Therefore, in the present case, your lordships, we understand by the interpretations put forth by all these judgments that the date of default thereby is not mandatory in submitting the application itself, all of which is most humbly submitted before this honorable court, your ladyship. If you have any questions for me, your ladyship, I would love to answer them, or I would like to leave the podium for my co-counsel to continue.
The co-counsel can continue.
Much obliged, your ladyship. It was a pleasure arguing before this court.
May it please this honorable court, this is counsel 2 for the appellants. I will be dealing with issues 3 and 4. With the permission of the bench, I would like to move on to issue 3.
You may proceed.
Much obliged, your ladyship. Issue 3 is whether or not the date of default changes based on the facts and circumstances, or whether it is to be taken as the date of NPA in all banking matters. Your lordship, the appellant submits submits 3 submissions. Firstly, the definition of default under the IBC is independent of NPA classification. Your ladyship, section 3 clause 12 of the Insolvency and Bankruptcy Code 2016 defines default as non-payment of debt when whole or any part of the amount has become due and payable or has not been paid. Therefore, the statutory trigger for insolvency here is the factual non-payment and not the date on which the loan is classified as NPA under the RBI regulations. The NPA label here is only an accounting consequence that occurs 90 days after the default of payment. It is not the legal date of default for the purpose of the IBC, Your Ladyship. In the case of Innovative Industries Limited versus ICICI Bank Limited, the Honorable Supreme Court has held that default is defined in Section 312 in a very wide term, as meaning non-payment of a debt once it becomes due and payable, and the court gets the moment the default occurs. Hence, under IBC, the date of default is a matter of fact, Your Ladyship. Secondly, the date of default may vary with acknowledgement on these date default is not immutable and may shift to a subsequent acknowledgement. In the case of Puneet Bhatia versus ASREC India, the NCLAT has observed that where subsequent documents, acknowledgements, or part payments are admitted, an amended or clarified default date can be allowed before final disposal. Also, in Veena Bank versus Shiv Kumar Reddy, the Honorable Supreme Court has held that a recovery certificate or an acknowledgement creates a cause of action to initiate insolvency proceedings. Therefore, where the debtors conduct, whether through balance sheet negotiations or settlements, acknowledges liability, the operative default date may be renewed. This approach recognizes commercial realities and also ensures substantive justice instead of restricting us creditors to a single static date, Your Ladyship. Thirdly, the judicial precedents support a very flexible and evidence-based result rather than a mechanical reliance on the NPA date. Your Ladyship, Section 238A, read with Section 238A of IBC, read with Section 18 of the Limitation Act, makes it abundantly clear that the written acknowledgements extend limitation. In the case of Asset Reconstruction Company India versus Vishal Jaiswal, again, the court has held that balance sheet entries and OTS proposals amount to valid acknowledgements and the same restarts limitation. In Jagdish Prasad Sarda versus Allahabad Bank, the Honorable Court has held that the date of default is fixed as the date of declaration of NPA. However, the default date does not shift unless there is any acknowledgement and the same reinstitutes fresh liability. The same in Ramdas Datta versus IDBI Bank, wherein the NCLAT accepted that the creditors may rely on acknowledgements to show the existence of a continuing default. Your Lordship, in the Supreme Court case of Babulal Vardaji Gurjar, the test is whether the debt continues to be payable and is payable on the date of filing. Thus, insolvency proceedings must hinge upon the continuing existence of debt and factual default, but not on a rigid NPA date. This ensures that valid petitions are not dismissed on technicalities and aligns with the court's rehabilitative and remedial spirit, Your Ladyship. I would like to move on to issue number 4 now. Your
Yes.
Ladyship permission.
Yes, you
Much
can.
obliged. Issue number 4 is whether a case can be admitted if default has occurred and the application is within limitation despite an error in the date of default. Your Ladyship, the appellant submits that once default and limitation compliance are established, an application under Section 7 cannot be rejected merely because the date of default was mistakenly mentioned. Firstly, Section 7 of the IBC makes it clear that the existence of default and limitation compliance are the very primary test for admission of an application. Section 7, subsection 5, clause A of the IBC stipulates that where the adjudicating authority is satisfied that a default has occurred and that the application is complete, it may admit the same. The same was reiterated in the case of Innovative Industries Limited versus ICICI Bank and another, where the Supreme Court has held the moment the adjudicating authority is satisfied that the default has occurred, the application must be admitted unless it's incomplete, in which case a notice may be given to rectify the same. Similarly, in ArcelorMittal India Private Limited versus Satish Kumar Gupta, the court has emphasized that the authority must ascertain default within 14 days and admit the application once satisfied. Further, in the case of E.S. Krishnamurthy and others versus Bharat High-Tech Builders Limited, the court has held that the NCLT here has two choices, Your Ladyship. It is either to admit the application once the default is proved or to reject the application if not. The adjudicating authority here cannot compel a settlement or defer admission beyond the statutory mandate, Your Ladyship. Therefore, when or whether a financial debt exists, a default has occurred and the application is within limitation, proceedings cannot be rejected merely due to erroneous mention of the default date. Secondly, Your Ladyship, an incorrect date of default is a curable procedural defect, not a ground for dismissal. In Dina Bank versus C. Shivkumar Reddy and another, the Honorable Supreme Court held that the adjudicating authority may allow filing of additional documents to advance the cause of justice, and technical lapses should not hinder a genuine insolvency claim if debt and default are otherwise established. Similarly, in the NCLT, in Canara Bank versus Wasabi Power Services, has held that the amendment of the date of default before the final adjudication is permissible if it does not alter the cause of action and the other party is given a fair opportunity to respond. In the present case, Your Ladyship, replacing the date of default from 1/5/2020 to 1/4/2014 merely clarifies the factual chronology. It neither alters the cause of action nor introduces a fresh claim. The amendment was made bona fide to reflect the true sequence of the events that had actually happened, Your Ladyship. Finally, in Swiss Ribbons Private Limited versus Union of India, the Honorable Supreme Court has emphasized that the IBC should prioritize genuine insolvency resolution rather than technical rigidity, Your Ladyship. And a mere clerical inaccuracy and in the date of default cannot defeat the legislative objective of a time-bound resolution and value maximization, which is the same case in the present case, Your Ladyship. Therefore, once debt, default, and limitation are established, admission of the Section 7 petition must follow, notwithstanding an error in the stated default date, Your Ladyship. If Your Ladyship is satisfied with issues 3 and 4, I would like to move on to the prayer, Your Ladyship.
We have one question. I wanted to ask you, why was the first dismissal in 2022 not challenged, and why did you not point out that the date of default was 2014?
Your Ladyship, when the OTS settlement was accepted, the corporate debtor did make a default, which is in 2020. That is why in the very first application, 2020 date was filed. But since it came under the Section 10A bar of the IBC, we filed a different application with the very first default date. In the present case, it is just replacing the date of default from 2020 to 2014, which is just merely clarifying the factual chronology, Your Ladyship. It does not alter the cause of action and does not introduce a fresh claim.
Okay.
May I move on to the prayer, Your Ladyship?
Yes, you can.
Much obliged, Your Ladyship. In the lights of the issues raised, arguments advanced, and the authority cited, it is most humbly prayed before this Honorable Court, and that may this Honorable Court be pleased to admit the second application under Section 7 of the IBC 2016 as valid in law, and to direct the initiation of the corporate insolvency resolution process for the respondent company, and or pass any other orders as this Honorable Court may deem fit and proper in circumstances of the case and in the interest of justice, fairness, equity, and good conscience. Much obliged, Your Lordship. It was a pleasure arguing before this bench, Your Lordship.
Chavi, who's next now?
Team 31, speaker 1, please start.
Audible? Sorry.
Yes, you are.
Thank you, ma'am. The council seeks permission to approach the virtual dais. The council.
You may.
The council seeks permission to address the bench as Your Lordship. Much obliged, Your Lordship. The council seeks permission to state the jurisdiction of the case.
You may proceed.
Your Lordship, the appellant has approached this Honorable Court, Supreme Court of Indigo, to deal with this matter under Section 62 of the IBC, and so does the respondent, and we most respectfully submit to the same jurisdiction. The council seeks permission to state the brief facts of the case. Your
You may
Lordship.
proceed with the arguments itself because they've already
Okay,
stated
Your
the
Lordship.
facts.
If Your Lordship is well versed with,
Them, do you have any other facts that you want to share?
no, Your Lordship. If you are well versed with the facts of the case, we can proceed with the issues.
Proceed with the issues and
Yes,
arguments.
Your Lordship. I would like to quickly state the statement of issues for Your Lordship's perusal.
You can.
Yes, Your Lordship. Uh, First issue is whether or not a second application under Section 7 of IBC is barred by law. Second issue is whether or not mentioning of dates of default is mandatory in application under IBC.
Yes.
And the third issue is whether or not the date of default changes based on facts and circumstances, or is it to be taken as a date of NPA in all bank matters. And the fourth issue goes as whether or not the case can be admitted if the default has occurred and the application is within limitation, despite an error in the date of default. Your Lordship, for your Lordship's kind information, I would be dealing with issue number 1 and 2, and my co-counsel would be dealing with issue number 3 and 4.
Okay.
May I proceed, Your Lordship?
Yes, you can.
Yes, Your Lordship. I'll be proceeding with issue number 1, Your Lordship. The issue number 1 is whether or not the second application under Section 7 is barred by law. It is humbly submitted on behalf of the respondents that we must note that IBC is a time-bound procedure, and we must go according to the timelines and deadlines. And even though we don't have any fixed or maximum limit regarding the applications we will be filing under Section 7, however, there needs to be some issues that needs to be considered, such as the maintainability of second application is subject to the cause of action, adjudication, like that's previous adjudication. If it is previously made, why should we if it is previously made in good terms and by considering all the facts, why should we consider and waste the court's time again and again? That should be considered, Your Lordship. And also, we need to consider the whether the parties are same or the claim is same, and we need to consider whether it is regarding the same default and all. So if a second application is founded upon the same default, same debt, then it is barred by the doctrine of res judicata and the finality of litigation principles, Your Lordship. Because there is no point in again and again going on the same thing and the court adjudicating the same issue by wasting its time, Your Lordship. And moreover, one point we need to consider here is that when the financial creditor has filed their first application before the NCLT, it has dismissed it based on merits, not on some or the other ground. Which means it has adjudicated it. After adjudicating itself, they can say that it is dismissed on merits, and there is no point in going ahead with that case. So this point must be considered strictly, Your Lordship, that it is dismissed based on merits and not dismissed based on some factual errors or XYZ, wherein we can say that it was not adjudicated. Now it is adjudicated, Your Lordship. It is clearly adjudicated, and we need not go ahead with second and third adjudication regarding the same matter, because it attracts clearly the doctrine of res judicata. Now, I would like to cite few case laws in my favor, Your Lordship. If Your Lordship permits, I would go ahead with the case laws.
You may proceed.
Much obliged, Your Lordship. In the case of Verenium Cloud Limited versus Rolta Private Limited, it was determined that a new petition submitted regarding the same financial obligation by altering the date of default is inadmissible, Your Lordship. And also in the case of Satyadan Ghoshal versus Dioranjan Devi, which is a very old case though, but there's a big paragraph. If Your Lordship permits me, I would like to read out certain highlighted paragraphs wherein the principle of res judicata has been clearly explained by the honorable judge in that case.
You may.
Yes, Your Lordship. It was clearly stated that the principle of res judicata is based on the need of giving a finality to judicial decisions. What it says is that once a res judicata, it shall not be adjudged again. Primarily, it applies as between past litigation and future litigation when a matter, whether on a question of fact or a question of law, has been decided between two parties and in one suit or proceeding, and the decision is finalized. either because no appeal was taken to a higher court or because appeal was dismissed or no appeal lies, neither party will be allowed in the future or a future suit or proceedings between the same party to canvass the matter again in the lower court. This is what is happening in the present case as well, Your Lordship, because just they were well aware and they have put the date as 1/5/2020. Based on that date, they have approached the NCLT, and the NCLT has adjudged it properly, and they have dismissed the case based on merits. So, Your Lordship must consider that this is the second being made, and that is also the appeal has also been dismissed by the NCLT, saying that NCLT was right. So, there's no point in Your Lordship considering this case again. It's nothing but wasting the court's time. So, if I may go ahead with the judgment part, this also says that the principle of res judicata is embodied in relation to suits in Section 11 of the CPC. But even where Section 11 does not apply, the principle of res judicata has been applied by courts for the purpose of achieving finality in litigation. We cannot keep on dragging the case and keep on taking it like for years together until one party achieves something they wanted in their favor. No, Your Lordship, it is something we need to. Justice is something done according to the facts of the case, not according to one person's own will. So the result is that the original court, as well as any of the higher court, must in any future litigation proceed on the basis of the previous decision was correct. So if the previous decision is given on merits and it is correct according to the honorable courts, they can go ahead with the appeals and all, but not the same issue cannot be again and again pondered upon. I would like to state the case of EBIC Singapore Private Limited versus COC Educom Solutions Limited. In this case, it has been observed that res judicata cannot apply solely because of the issue has previously come up before the court. The doctrine will apply where the issue has been heard and finally decided on merits through a conscious adjudication by the court, which has already been done by the NCLT, Your Lordship. In the present case, the second application is barred because it was dismissed by the Honorable NCLT, and there was no bar because of there was a bar because of Section 10A. Your Lordship, I would also like to bring it before you that on one the applicants have put the date as 1/5/2020, and the court has stated that 1/5/2020 is attracting Section 10A. So just because the court has stated that it is attracting Section 10A because of that, they cannot change the date according to their own whims and fancies, which is again, this is bad to the judicial process as such. And it is finally submitted that another petition on the same cause of action on same grounds by renewing the date of default is not permissible under law, and it attracts the doctrine of res judicata as it has already been adjudicated by the honorable tribunal and appellate tribunal, and moreover the case has been dismissed on merits, Your Lordship. If Your Lordship is good with this, I can go, or if I have to answer anything, I would.
I wanted to ask you one question. Do the
Yes, Your Lordship.
OTS letters up to 2022 constitute a valid acknowledgement under Section 18 of Limitation Act, making the 2024 application timely?
Your Lordship, the OTS, you're talking about the OTS letters, right, Your Lordship?
Yes.
Your Lordship, we have been behind them, behind the appellants, asking them continuously for OTS, Your Lordship. Every year, you can see right from in 2014, there has been a default. We are not denying the default. We have been behind them, stating that from you can check 1/1/2017, 1/1/2018, 1/1/2019. We have been behind them, asking them to grant us permission to do a one-time settlement. None of the years they have given, and finally in 2020, after the letter we issued on 1/1/2020, on 1/2/2020, OTS was sanctioned. Fine, good. OTS was sanctioned, but soon after that, in 2020 March, there was COVID. There is no business happening. How even if they have granted us OTS, we cannot just right away give them everything. We need to also check few things with our company, like there will be employees welfare. We need to check after the company's running position, everything. So obviously during COVID, we were in no position to repay anything. That is the reason section amendment to section 10 amendment was made to the IBC, and section 10A was brought in as well.
Yes.
So we have to consider this point, Your Lordship. So the thing is, they in their first application itself, they should have put the date as somewhere in 2014, but that has not been made. And soon after, the court denied the same, saying it was barred by 10A. In order to subside the 10A, this thing, they had again filed a new date.
Yes.
Yes, Your Lordship.
You can proceed with the next issue.
Yes, Your Lordship. Thank you. Much obliged, Your Lordship. Second issue is whether or not mentioning of dates of default is mandatory in application under IBC. It is humbly submitted by the respondents that it is mandatory to mention the exact date of default, Your Lordship, because this is a time-bound process, as I have already stated before, Your Lordships. When this is a time-bound process, we need to calculate the limitation periods, exactly the 90 days timelines and whatever timelines are there. We need to calculate them accordingly. So mentioning the exact date of default would help the court go ahead with the litigation process or whatever the CARP process is, whatever the process the company is going through. Now, sticking to this issue, it has been mandated by the code, Your Lordship. The rules, there are code rules and forms that have been given by this insolvency and bankruptcy code. So I would like to draw Your Lordship's attention to Section 7, Clause 3, Subclause A of the IBC. It requires creditors shall, along with the application, furnish record of default recorded with the information utility or such other record or evidence or default as may be specified by the court. This implies that the date of default is mandatory to record such evidence when an application is being made under IBC. Without a date of default, we cannot just come before your honorable lordships and we cannot say that it has happened so and so on so and so date, and we cannot just barge in before this courts and waste your honorable court's time, Your Lordship. So when an application is being made under Section 7, the application is made as per one form. That is Form 1, Part 5, point number 8. That point clearly specifies that in order to prove the existence of financial debt, the amount and date of default are to be proved by attaching necessary documents. If your lordship is satisfied with this, I would like to state some case laws in my favor, Your Lordship.
You may proceed.
Much obliged, Your Lordship. The tribunal in this case, in the case of Kondaboyina Srinivas Krishna versus PVM Invisis Private Limited, held that date of default is considered crucial in limitation as well as in establishing that a debt is due and payable. The notice must clearly indicate the date of default to ensure that indebtedness and date of default are identifiable. If you are not clear as to what is the date of default, you can keep on changing the limitations, Your Lordship. That does not do justice to one party.
Yeah.
Because it is completely on the side of other party. Therefore, mentioning the date of default is very crucial for determining the date of default as well as limitation, Your Lordship. Yes, Your Lordship. I'm done with my issues. If Your Lordship has some more questions.
That's it.
My co-counsel would proceed with issue number 3 and 4, Your Lordship.
Sure.
Thank you.
Please, Honorable Court, I address counsel number 2 on behalf of respondent, that is corporate debtor. With permission of this honorable bench, I shall now proceed to address issue number 3 and 4. And thereafter with the year. Much obliged. Issue number 3 deals with whether the date of default changes based on facts and circumstances, or is be taken as the date of non-performing asset in all bank matters. Your Lordship already submitted before this honorable court that ABC Bank has sanctioned 500 crore to the respondent, and the account was later classified as NPA on first. It's consistent and it has been admitted by both the parties, and therefore, as on 1st April 2014, the default stood crystallized and the And this is the first and original cause of action which arose in 2014. Now, multiple OTS and restructuring requests were sent by corporate debtor beginning from 2014 and up to 2022. These proposals were acts of negotiation, not acts creating a fresh legally binding repayment structure. Even the OTS sanctioned on 1st February 2020 was cancelled on 1st of May 2020 due to non-payment. Therefore, there never existed any fully valid and performed settlement from 2014 that could generate a new default date. And this is the most crucial point because an OTS proposal does not erase the original default unless it is successfully executed. Since no OTS was executed, the legal default date remains same as 2014. But what the appellant over here has done is that in the first Section 7 application, they declared their default date as 2020. And when that application was dismissed under Section 10A, they filed a fresh Section 7 application with a new default date as 2014. Your Lordship, the default date did not change. The appellant has changed it to their requirements. The response that this cannot be permitted under the IBC. And once the date of default is asserted, the creditor cannot re-engineer it to defeat the statutory protections, limitation period, or prior adjudications. Uh, the jurisprudence is very clear that there are various case law stating this. I may request your lordship to cite few case laws regarding our favor. If you may proceed. So there are few case laws which Gaurav Hargovind by Dave versus ARC. In this, the court has stated that the NPA date is the date of the default for limitation computation. And in Babulal Vardaji Gurjar versus Veer Gurjar Aluminium Limitation, uh, Aluminium, the court has stated that limitation period begins as on NPA date. And in the present case, the NPA date is 2014. Since 2014, there have been multiple consecutive letters of mm, letters issued by restructuring facilities, but there is no clear evidence stating that they have been fully repaid as on letter which has been given. So the original date of default would exactly be as 2014. There's no uh, there's no like it has been admitted from the very start by the corporate debtor itself. And in the case of Bank of Baroda versus Virginia developers, the court has stated that creditors cannot alter default dates to fit procedural schedules. And in this case, that's the thing going on with the creditors. They have been like changing the default dates as they would like to. And in Ramesh Kamyal versus Siemens Gamesa, the court said that a creditor cannot replace a chosen default date to bypass statutory bars. Allowing such alteration could set a dangerous precedent. Like every time a Section 7 application is rejected, the creditor will simply pick another date and try again. That would mean that there's no finality to the case. And there'll be no legal certainty when the dates keep on changing. And it's a problem of endless for the corporate debtor. And this is exactly what and this is the exact reason why IBC was enacted to prevent. Therefore, on issue 3, the respondent humbly submits that on lawful, consistent, and enforceable date of default is 2014 as the NPA date, and the appellant cannot alter it at any convenience to avoid Section 10A. I would like to proceed with issue number 4 if you
if your lordship does not have any questions.
You may proceed.
Thank you, lordship. Issue number 4. The issue number 4 is whether a case can be admitted if the default has occurred and the application is within limitation despite an error in the date of default. Your lordship, over here, the appellant takes a very simplistic stance that they argue that debt and default exist, therefore the case must be admitted, and that the change of default date is merely an error. The respondent respectfully disagrees on this matter. Under Section 7 of the IBC, a petition is valid only when the debt, default, and the date of default are correctly. The date of default is not a clerical field. It is the basis of the jurisdiction. It decides whether limitation has expired and whether Section 10A applies or not. And changing the date of default therefore changes the very cause of action. In the case of Dana Bank versus C. Shivakumar Reddy, curable defects referred to, like in the case, were missing documents, typographical mistakes, and procedural irregularities. However, the judgment never permitted a creditor to rewrite the date of default to restart limitation or avoid statutory protection. On the other hand, in the case of Rolta Private Limited versus Venerium Cloud Limited, the court has specifically held that a Section 7 application on the same debt but with a new default date is not maintainable and such defect is not curable. Now, if the appellant truly believed that the date of default was 2014, nothing prevented them from using the date in the first application. But they themselves asserted the date as 2020. That date was deliberately chosen by themselves. The first petition was adjudicated and dismissed under Section 10A by both NCLT and NCLAT. The appellant did not challenge those findings. Rather, they changed the date and refiled the case, hoping for admission. This case is not about technical defect, but this is about the inconsistency of pleadings, strategic modification of facts, and evading of past adjudication. Uh, Therefore, on the issue number 4, the respondent concludes that even if debt exists, the case cannot be admitted because the appellant has altered the foundational date of default after adjudication, which is impermissible under IBC, judicial precedent, and principles of clean pleadings. Therefore, the council is done with the issues. If your lordship has any questions, I'd like to answer. Otherwise, I'll proceed with prayer. Much obliged, your lordship.
You can proceed with the prayer.
Much obliged, your lordship. It is humbly prayed by the respondents that to hold that the second application dated 2024, like 1st January 2024, filed under Section 7 is barred by law, attracting res judicata and non-alteration of date rules, and declare that the date of default is an essential element to be considered to file an application under IBC, and also dismiss the application filed by the appellant with cause and pass any such order, writ, or direction as the Honorable Court deems fit and proper in the light of justice, equality, and good conscience.
Your ladyship, will you permit 2 minutes to submit rebuttals, your ladyship? Your permission.
Do we have time for that?
No, ma'am. There's no time for rebuttals or rebuttals.
Okay.
Ma'am, may I request you to